Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. It is our regular practice that we recite preamble with a sense of commitment and with a sense of sentiment, and we feel that preamble is our unity and preamble our dignity. So therefore, I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. So, with your permission, let me move on to the next topic, which is very, very important and touching the legal profession, and it is professional ethics. Because for an AOR examination, the third paper is professional ethics, and we have selected what are the frequently asked questions, and those questions are being discussed. The topic for today is ethical for a lawyer to resort to strike? Can he go on strike? That is the question. Now let us ask ourselves, can we go for a strike? If we go for a strike, how the litigants are affected? How the administration of justice is affected, hampered? So the Advocates Act says, the Advocates Act with Bar Council of India rules, which specifically says that advocate's duty towards the court, towards the client, towards your colleagues, towards the society at large, because we are considered to be a privileged community. We are considered to be a noble profession and a learned profession and a role model for other professions. So we are a privileged persons in this society. So therefore, when a client has a problem, he comes to us. We file a case and we stand for justice. We try to bring justice to the client through court of law. But if an advocate has got a problem, why does he not approach the court, or why does he not invoke the statutory remedies or other remedies, whatever is available? Why should he go for strike? That is the question. If he goes for a strike, what are the consequences? First and foremost is, client engages a lawyer. For what purpose? Reason is, client thinks that as a common man, he is unable to understand what is the provision of law. He is unable to understand what is High Court judgment, what is Supreme Court judgment says, and how to interpret and how to apply those laws to his facts and circumstances. He is a layman. He doesn't have a knowledge of law. Therefore, he strongly believes that lawyer will fight. He is expert in this field of law. Therefore, he will bring justice to us. So therefore, he engages us, not only asking us to provide this service, we are being honored for our service. So therefore, when his case is called out in the court and we are not attending the court, and we are conducting strike outside the court premises, when case is called out, nobody appears, and any court will not take the cognizance that strike is going on, therefore case will be adjourned. No, that is not the law. They will say that whatever the strike, but you must attend to the court. That is what duty towards the court. If you do not approach, what will happen? The case will be dismissed for non-prosecution. They may adjourn the matter. That is one possibility. The yet another possibility is they will say dismissed for non-prosecution. Who is aggrieved? Now the next question is, who is aggrieved? First and foremost is client is aggrieved. He had a grievance. To redress his grievance, he has engaged a counsel, and he has paid counsel to represent him. And when case is called out, advocate did not appear, and now it is dismissed. Therefore, he loses maybe property or any other rights, or for what purpose he has gone, that is not redressed. So first and foremost is client is aggrieved. What about us? We are also aggrieved indirectly, dear friends, because client is the paying master. If client is going to say this lawyer will never come to the court, they will always resort to strike, then where do we get the case to contest? And ultimately, the justice delivery system will be collapsed. The legal profession will be under a big question mark. So therefore, we are sitting in a glass palace and we are throwing stone at our palace. Who is going to be aggrieved? Lawyers, court, at last the society is aggrieved. So therefore, dear friends, the Honorable Supreme Court has held in landmark judgment, Constitution Bench judgment, in which case they have said lawyer cannot resort to strike. That is the law. Whatever may be the situation, please address through proper course, maybe a statutory remedy or any other remedy as available to a common man. It is applicable to lawman also, more applicable to lawman. So therefore, dear friends, strike, whatever whether associations calls for a strike, or bar council calls for a strike, or individuals they call for a strike, that is illegal. But there is always subject to an exception. What is the exception? To maintain the dignity of the bar and the bench, we can call for a token day, 1 day strike. So on that day, the Honorable Court may excuse us only for 1 day. That too, when the dignity of the bar and bench is at stake. Or otherwise, if we have a grievance which may go for more than 1 day, what we can do? We can give a press statement. We can even give interviews in the media, or we can have armband put up, or you can even go for fasting. You can carry even placard, not inside the court but outside the court. You can do that, but whenever matter is called, you must attend to the court. So what is the crux is, the lawyer cannot resort to strike. If association says we have called for a strike for this reason, so therefore you being a member of the association, you cannot go on strike. The lawyer is boldly, fearlessly can say, no, I have a duty towards the court, therefore you need not listen to the association. That is what the law says. Now let me take you to that very important judgment, dear friends. What is the case I am talking about? This is a Constitution Bench judgment and frequently asked questions. 2003, Volume 2 Supreme Court Cases, page number 45. 2003, Volume 2 Supreme Court Cases, page 45. The ex-captain Harish Upal versus Union of India. This is frequently asked questions, dear friends, in your examination. So I request each one to read this judgment in full. So ex-captain Harish Upal versus Union of India. This is comprising of 5 honorable judges. It is a constitution bench judgment. Honorable Justice G.P. Patnaik, Chief Justice. Honorable Justice M.B. Shah, Duraiswamy Raju, Honorable Justice S.N. Variava, Honorable Justice D.M. Dharmadhikari. In these cases, I would like to take you to certain relevant portions. They have discussed about what is the settled law on strike. This is exactly the question asked in our AOR examination. By referring to all the cases, they have summarized what is the law. Thus, the law is already well settled. It is the duty of every advocate who accepted a brief to attend trial, even though it may go on day to day and for a prolonged period. It is also settled the lawyer who has accepted a brief cannot refuse to attend court because a boycott call is given by the Bar Association. It is settled law that it is unprofessional as well as unbecoming for a lawyer who has accepted a brief to refuse to attend court even in pursuance of a call for strike or boycott by the Bar Association or the Bar Council. It is settled law that courts are under an obligation to hear and decide cases brought before them and cannot adjourn matters merely because lawyers strike are going on. The law is that it is the duty and obligation of courts to go on with matters. Otherwise, it would tantamount to becoming a privy to the strike. It is also settled law that if a resolution is passed by bar associations expressing want of confidence in judicial officers, it would amount to scandalizing the courts, to undermine its authority, and thereby the advocates will have committed contempt of court. Lawyers have known, at least since Mahabir Singh case, that if they participate in a boycott or a strike, their action is ex face bad in law, bad in view of the declaration of law by this court. A lawyer's duty is to boldly ignore a call for strike or boycott of courts. Lawyers have also known, at least since Raymond Service cases, that advocates would be answerable for the consequences suffered by their clients if the non-appearance was solely on grounds of a strike a call. So it is always a lawyer's duty to attend to the court. Now, what is the effect of frequent strikes? What will happen when lawyers frequently go for strike? It was expected that, having known the well-settled law and having seen that repeated strikes and boycotts have shaken the confidence of the public in the legal profession and affected the administration of justice, there would be self-regulation. The above mentioned interim order was passed in hope that with self-restraint and self-regulation, the lawyers would retrieve their profession from lost social respect. The hope has not fructified. Unfortunately, strikes and boycott calls are becoming a frequent spectacles. Strike, boycott calls, and even unruly and unbecoming conduct are becoming a frequent spectacle. On the slightest pretense, strikes or boycott calls are resorted to. The judicial system is being held to ransom. Administration of law and justice is threatened. The rule of law is undermined. See, we think that it is only an association resorting to strike or bar council has called for a strike, but it is a threatened. It's a threat to law and justice. The rule of law is undermined. Ultimately, dear friends, After discussing everything, the Honorable Supreme Court has said, if the bar has got some grievance, then they can set up a grievance redressal committee. And this redressal committee can bring the matter either to the, if it is a trial court lawyers, they can bring it to the district court judge. If it is a high court lawyer, they can bring it to the chief justice. And whatever the chief justice says or the district judge says, that becomes a fine. So they cannot go beyond what the judge says. But what is the exception here? Exception is the only exception. So I am always afraid when there is an exception, because in the family law, when divorce, granting divorce was challenged before the court of law, the Honorable Supreme Court has held the reunion of the family, the restitution, the reunion of the family is always a rule. But it is like a window. Divorce is like a window. Therefore, if a person is unable, is suffocating within the family life, through a window, he can get fresh air. And divorce is a window, it's an exception. So union of people, union of couple is the rule. The exception is the divorce. Now the door has, general rule has become an exception, and the exception has become a rule. So therefore, in the similar way, it should not happen, dear friends, because we as a lawyer, and we have no barriers, and the court at times, they don't even look at the pleadings. They will make the record our submissions made at the bar. Based on our submissions, the orders are passed. So see the confidence that the Honorable Supreme Court or honorable courts have on the lawyers community. So therefore, we should act in such a way that it should always inspire confidence for the public at large in the institution called judicial institution. So what is that exception? The only exception to the general rule set out above appears to be item 3, that is, we accept that in such cases a strong protest must be lodged. We remain of the view that strikes are illegal. They are remaining the advocates, strikes are illegal, and the courts must now take a very serious view of strikes and calls for boycott. However, this is only the exception. However, as stated above, lawyers are part and parcel of the system of administration of justice. A protest on an issue, what sort of issue we can go for strike, token strike, that is dignity, integrity and independence of the bar and the judiciary, provided it does not exceed one day, may be overlooked by courts who may turn a blind eye for that one day. For one day we may turn out to be turn blind to that particular strike. Only on that particular day, the remaining day you must come. So what is the exception is very important, dear friends. So the dignity, when there is an issue involving dignity, integrity and independence of the bar and the judiciary, we can go for a token strike, that is only for one day. Otherwise, it is not so. So finally, it is a rarest of rare cases. The general rule is we cannot go for strike, but rarest of rare case that as a token strike, we can go for one day. So this is what the Honorable Supreme Court has held. And finally, last paragraph I am concluding, dear friends. It is true that advocates are part and parcel of the judicial system. As such, they are the foundation of the justice delivery system. It is their responsibility. It is our responsibility, not their responsibility, our responsibility. It is our responsibility of seeing that justice delivery system works smoothly. Therefore, it is for each and every bar association to be vigilant in implementing the resolution passed by the Bar Council of India of saying that there are no further strikes anymore. So this is an observation made by the Honorable Supreme Court. So therefore, let me sum up, dear friends. So whether is it legal for a lawyer to resort to strike? The answer is no. The lawyer cannot go on strike or boycott the court for any reasons. Otherwise, administration of justice will be affected. Legal profession will get severely affected. What is the exception? Only when the issues involving the dignity, integrity, independence of the judiciary and the bench, only under circumstances you can go for a strike, but it should not exceed more than 1 day. On that 1 day strike, we as a court may turn a blind eye to that strike for only 1 day. The next day you must appear before the court to uphold the majesty of law, to administer the justice, so to assist for the administration of justice. So with this, dear friends, I am truly honored to deliver a presentation on these two topics.